Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and today we are going to discuss a very important topic. The title of our today's discussion is Doctrine of Separation of Powers. Power corrupts and absolute power has a tendency to corrupt absolutely. So what is indicated by this statement or a very famous quote that the political system should be stable and checks and balances should be maintained among the three organs of the government. So with this, let us understand what is doctrine of separation of powers. In this discussion, we will be studying about the meaning of the doctrine of separation of powers. We'll also see a comparative analysis of doctrine of separation of powers in various constitutions. Then we are also going to see how this doctrine has been diluted by the Jan Vishwas Act of 2022. And in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So now let us proceed to understand the background of our today's topic. If we talk about the background of our today's topic, the Jan Vishwas Act has been recently enacted by the Parliament and it effectively dilutes the doctrine of separation of power, because in the Jan Vishwas Act, the judicial function has also been given to the bureaucracy. We'll study about this in our further slides, but let us first understand the meaning of this doctrine of separation of power. So if we talk about the doctrine of separation of power, so go back to your 10th class political science book. You have heard about the or studied about the horizontal distribution of power. Horizontal distribution of power. So the concept of horizontal distribution of power talks about the distribution of powers among the three organs of the government, that is the judiciary, legislature and the executive. So this is what is exactly the doctrine of separation of power. So the doctrine of separation of power was evolved by or first propounded by Montesquieu, a French scholar, in his book The Spirit of Law. So the book name was The Spirit of Law, and if I write the Latin version of this book or the original name of this book, it is Spirit de Louis. So Spirit de Louis or The Spirit of the Law was the book in which Montesquieu propounded the doctrine of separation of power. The doctrine of separation of power essentially talks about the separation of power between three organs of the government, that is the legislature, executive and the judiciary. So the concept of this doctrine is to remove the abuse of the power by the authorities. So we have studied in this our political science book as well that power should not be concentrated in one hand. Why? Because it will lead to autocratic form of government, which is not good for the society, and that is why there is a strict need to implement the doctrine of separation of power so as to maintain checks and balances amongst the three organs of the government. This doctrine says that no organ of the government can exercise the power other than what is given to them. So it is talking about a watershed compartment, that is judiciary, executive and legislature are somewhere in a tight fill compartments, and these compartments like judiciary cannot encroach upon the function of the executive and executive cannot encroach upon the function of the legislature. So this is in essential the meaning of the doctrine of separation of power, that the organs of the government perform a well-defined functions which is given to them by their own respective constitutions. So, and they cannot encroach upon the functions of the other governments of the other organs of the government. So this was all about the meaning of this term doctrine of separation of powers. So it essentially depends on four fundamental principles. And what are they? So the first principle is exclusivity. Exclusivity is division of the organs of the government into executive, legislature and the judiciary. Legislature and the judiciary. So I have explained this before also, that the government horizontal distribution of power divides the government organs of the government into three parts, that is the legislature, executive and the judiciary. And the exclusivity principles talk about this division only, that they should be divided in order to function efficiently. Then functional principle. Functional principle essentially states that the functions of one organ of the government cannot be performed by some other organ of the government. So, for example, executive cannot do what the legislature will do. Legislature cannot do what the judiciary will do. So, the function of one organ of the government cannot be performed by the other organ of the government. Then comes the principle of checks and balances. It states that every organ will maintain a check and balance on the other organ of the government. For example, legislature maintains a checks and balance on the executive, and executive maintains a checks and balance on the judiciary, and judiciary maintains a checks and balance on both legislature and the executive actions. And why is this so? So that they can perform within their own constitutional spheres that has been granted to them. So it is important that all of these three organs maintain a check and balance on each other to function efficiently. Then there is the function of mutuality. What does this mean? It means concord, cooperation, so the function of mutuality means concord, cooperation and engagement. So what do we understand by this? So the organs will concord with each other. They will not function in disharmony or disagreement. They will function with cooperation and they will engage with one another to perform their functions well. So this was all about the doctrine of separation of power, its meanings and the principles on which this doctrine of separation of power is dependent upon. Now let us understand the comparative analysis of the doctrine of separation of powers in various constitutions. So if we talk about the US Constitution, Article 1 and Section 1 of the US Constitution gives all of the legislative powers to the Congress, US Congress. So the legislative power is vested in the Congress of the USA. As per Article 2, Section 1, the executive power under the US Constitution lies with the President of the USA. And then Article 3, Section 1 talks about the judicial power. And it lies with the Supreme Court of the United States of America. So this is the division of power under the US Constitution. But this division is not strict. Sometimes what happens is when the Congress has brought a legislation, it can be vetoed down by the President. And similarly, if an act has been brought by the Senate in the US, it can be struck down as unconstitutional by the US Supreme Court. So we cannot say that they are put in a very watershed compartment. Judiciary, executive and legislature. So in the case of USA, we cannot say that they are in a very watershed compartment, though they have well-defined powers and they cannot in ordinary cases exceed the power given to them. Now let us talk about the United Kingdom. So in United Kingdom, there is no strict separation of powers. The monarchy is the nominal head in UK, the parliament being the original head. What happens in UK is there is a House of Lords. House of Lords. So this is one body in the UK, House of Lords, known as the House of Lords, and it performs both judicial and legislative function. So the concentration of power is in this body known as the House of Lords. So that is why we are saying that there is absolutely no concept of separation of powers in the UK. And in the UK, what also happens is that the judge of the Supreme Court can be removed by the Parliament, which is not there to in the doctrine of separation of powers. Doctrine of separation of powers talks about clear-cut power division between the three organs of the government. But in the UK, as the judiciary is also dependent on the decision of the Parliament. For that matter, the removal process of a judge is entirely dependent on the Parliament, states that there is absolutely no separation of power in the United Kingdom. But if we talk about India, let us analyze the constitutional provisions of the Indian Constitution. So the first principle is Article 50, which forms the part of the directive principles of state policy in our Indian Constitution. So this Article 50 puts an obligation over the state to separate the judiciary from the executive. But as it is a directive principle of the state policy, it is not legally enforceable. Then comes the ordinance making power of the president under Article 123. So you know that whenever the Parliament is in recess and a law has to be made on a subject which is of national importance, then Article 123 of our Indian Constitution grants the power to the president to promulgate an ordinance regarding the same, and it will have the same force as the law made by the Parliament. Then comes Article 121 and 211. These provide that the legislatures cannot discuss the conduct of the judge on the floor of the Parliament. So the general conduct of the judiciary cannot be discussed on the floor of the Parliament or the state legislatures until and unless their impeachment is in question. Then only they have the power to discuss the conduct of the judge. Else they do not have a general power to discuss the conduct of a judge on the floor of the House. Then comes Article 361. The President and Governors enjoy immunity from court proceedings. Why? Because they are very important officials. They have to have a certain kind of immunity within our Indian Constitution. And Article 361, under Article 361, they are immune from any court of proceedings. So this is the division of power in our Indian Constitution. And we can say that somewhere or the other, the Indian Constitution does accept the doctrine of separation of power, but it is in a very liquefied form. It is not in a very strict manner. Because what we often see that the legislative in India can perform the judicial functions as well. Then executive can perform the legislative functions as we have seen in Article 123. So the doctrine of power is present in India, but in India we have a unitary tilt of our Indian Constitution. That is why Indian Constitution is quasi-federal in nature. It is not completely federal in nature. So if we talk about India, the doctrine of separation of power is in essence is present. Now let us discuss what the new Jan Vishwas bill has said and laid down and how it has diluted the doctrine of separation of power effectively. So if we talk about the Jan Vishwas Act, it is a very recent legislation passed by the Parliament to enforce ease of doing business in India. So the legislation is aimed at improving ease of doing business in India, because India is currently trying to be a manufacturing hub. We need laws so that the foreign direct investments happen in our country and we are able to boost our manufacturing sectors. So what has this Jan Vishwas Act done? It has decriminalized various offences across 42 legislations. And what does it talk about the division of power? So this legislation has mostly replaced criminal imprisonment with penalties, and it has transferred the power to impose these monetary penalties from the judiciary to the bureaucracy. So what has happened is the bureaucracy is under this act is acting for its own cause, and the power to impose penalty, the power to conduct inquiry and then decide what the amount of penalty should be, is completely in the hands of the bureaucracy and not in the hands of the judiciary. And this is the problematic part of the Jan Vishwas bill. So what are the other instances in which the doctrine of separation of power has been diluted? So let us see. So before when we got independence and our constitution came into force, there was no separation of power between a judicial magistrate and a criminal magistrate, or we say that the judicial magistrate of first class. This only happened after the enactment of the Executive Functions Act. Executive Functions Act of 1970. So this division happened under the Act of 1970, and it effectively divided the powers of executive magistrate and the judicial magistrate in the Code of Criminal Procedure 1898. Then the the executive also creates tribunals. So since the 1980s, the bureaucracy has been trying to avoid the judicial scrutiny, and by creation of tribunals, what happens is a senior bureaucrat is often a technical member in this. So there is involvement of bureaucracy in these tribunals as well. That is why when we say the judges of Supreme Court, when they retire, they can be the chairperson of the tribunals. But the bureaucrats are also involved in the tribunals by being a technical members. Then the bureaucracy has also laid down certain regulatory authorities, statutory regulatory authorities such as the SEBI and the CCI. So the Securities Exchange Board of India and the Competition Commission of India have the power to impose penalty on private players. And what happens is these bodies are often headed by the senior bureaucrats. So although they are imposing penalty, they are being headed by whom? The senior bureaucrats. Then adjudicatory officers under different acts such as the Prevention of Money Laundering Act, IT Act, etc. Even under the Jan Vishwas Act also, that officer who will be conducting an inquiry and imposing a penalty will be he will be an adjudicatory officer. So effectively, the bureaucracy is only playing the role of judiciary in case of the Jan Vishwas Act as well, and that is why I am reiterating that this is against the constitutional scheme of the doctrine of separation of powers. Doctrine of separation of powers. Why? Because huge power is given to the adjudicating officer under the Jan Vishwas Act. He is empowered to analyze the facts and circumstances of the case. He is also empowered to conduct an inquiry, and he is also empowered to impose a penalty. So in case of transparency, they would have suggested that okay, you can challenge the order of the adjudicatory officer in the court, and then the court will ask the government to put forward its case, and the other party will also put forward the case, and then the fine of penalty can be challenged. But no such provision is there in the Jan Vishwas Act, and which has effectively granted the bureaucracy to act as in the judicial function. So important test has been laid down by the Supreme Court known as the judicial function test, and this test suggests that any function which involves and which comes within the purview of judicial function cannot be performed by the executive. So the question under the Jan Vishwas Act, whether the analyzing of facts and circumstances of the case, whether conduction of an inquiry will amount to the judicial function, it is yet to be interpreted by the judiciary because it is comparatively a very new legislation. But if we talk about the judicial function test in general, it lays down that the executive cannot perform the functions of the judiciary or functions which are judicial in nature. So with this, we come to a conclusion of our today's discussion. We have discussed the doctrine of separation of powers. We have also done a comparative analysis of the doctrine of separation of powers in various constitutions. We have also seen how the Jan Vishwas Act effectively has given the judicial power or the judicial function to conduct inquiry in the hands of the bureaucracy. We have also seen various other instances when the bureaucracy is trying to avoid the eye of the judicial scrutiny. Then the moot question that remains in this today's discussion is conducting of an inquiry a judicial function? If yes, whether giving the power to the bureaucracy to not only adjudicate the facts and circumstances of the case, but also impose fines in the nature of penalty will amount to a judicial function. So, the interpretation is yet to be seen because this is a very new legislation. But do ponder upon this question and do ponder upon that why I am saying that the judicial doctrine of separation of power has been diluted by the Jan Vishwas Act. Now let us understand a practice question for your prelims examination. So the question is, consider the following statements. Statement number 1 is doctrine of separation of powers is borrowed from the US Constitution. Statement number 2 is doctrine of separation of powers is mentioned under Article 50 of the Indian Constitution. Statement number 3 is Indian Constitution follows a very strict policy of the separation of powers. Which of the following statement given above are correct? Your options are: option number A is 1 only, option number B is 1 and 2 only, option number C is 2 and 3 only, and option number D is 1, 2 and 3. Kindly drop your answers in the comment box below. Now let us see a practice question for your mains examination. The question is, judicial legislation is antithetical to the doctrine of separation of powers. Comment. And this is a PYQ which was asked in your GS paper 2 of 2020, and it also talked about presenting of public interest litigations, flooding of public interest litigations in the judiciary. But we are concerned with the question that whether judicial interference or exercising of legislative powers by the judiciary is antithetical to doctrine of separation of power. In the introduction, you will mention the doctrine of separation of powers. Then you will draw a distinction between various constitutions. You will write the provisions of the Indian constitutions which enforce the doctrine of separation of powers. You will also distinguish between the functions of the judiciary and functions of the legislature and overlapping between them. And you can conclude that yes, if the judiciary time and again asks the parliament to enact the law or interferes in the legislative procedure of the parliament, then definitely the judiciary is encroaching upon the power of the parliament, and this is done mainly in the case of judicial activism. So you can conclude that yes, if over exercise of power is done by the judiciary in the matters of the legislative powers of the parliament, then definitely it is a dilution of the doctrine of separation of power as envisaged in our Indian Constitution. I hope this session was insightful for you. If you liked today's discussion, kindly like the video and subscribe to our channel for more such updates. If you have any feedback regarding this session, you can also drop it in the comment box below. Thank you.